Good afternoon, everyone, and welcome to our AVLA webcast on avoiding litigation, the role of mediation in workplace disputes. I'm Tamsin, an Associate Director from our Melbourne office, and I'm here with my colleague,
Kate Thomson from our Newcastle office. Thanks, so nice to be with you.
And we've got quite a bit to cover today, Kate, so we're going to set out what's on the agenda. We're going to start off by talking about what is mediation, what is this entire topic all about? I'm sure a lot of people have probably dealt with things like conciliation before, litigation, but what's the difference between all of that and mediation? We're then going to talk about how this actually works in a workplace setting, because you might have heard about mediation in things like maybe family disputes or even just if you're fighting with your neighbour over your fence. But how does that actually translate in the workplace? We're then going to look at when's it's effective, when is it not effective. And I think that's the big kind of question, particularly for anyone who's a HR practitioner. When do I use this, when do I not? How does this interplay with things like investigations and the like? We're then going to talk about, should I have a neutral third party? Should I do the mediation if I'm the HR practitioner in the business, or when do I outsource this to somebody else? We're then going to very lightly touch on this thing called AMDRAS, which is the Australian Mediator and Dispute Resolution Accreditation Standards. It's quite a mouthful, but it's basically the standards for accredited mediators. And Kate and I are both accredited mediators, so we're going to take you through a little bit of just understanding what those standards are. And if you're thinking of accreditation, it's good to be aware of them. And last but not least, we've had quite a few helpful, I think, common questions come through. So we're going to touch on some of those. And then anything else anyone else would like to send in as we go through today. So should we get started?
Let's get started. Let's get through. So what is mediation? Well, it's not to be confused with medication or meditation, though you may need one or both of those things after going through a mediation process, but that's what we're trying to avoid. So we'll see how we go with that. No, what we're talking about is it's a structured negotiation or dispute resolution process. So it's a way of getting to an outcome, trying to resolve some problems, usually between two people, with an independent third party there to assist the people involved in the dispute or the conflict in trying to see that way through. Often arises in circumstances of conflict, but it doesn't always have to, and I think that's an important consideration. We will, as Tamsin said, talk about some of the instances or circumstances in which mediation is appropriate. And I think you'll see there that you'll start to maybe have a broader understanding or appreciation for where mediation might be appropriate. And as I said, doesn't always need to be where people hate each other and can't talk to each other. What are we trying to do? Well, we are really getting to the core of issues. So work out what the problems are between two individuals. Are they communication based? Are they personality based? Is it something else entirely? Is it structural within our organisation? So working out all of those things, talking about our feelings, something Tamsin and I absolutely love, and then working out some options for resolving conflict or to move forward in other ways.
Now, there's an interesting question on the end there where you said it's distinct from an investigation.
Yes.
What's this distinction?
So really important to understand with mediation, and we will talk a little bit about the other forms of mediation that our audience might be more familiar with. For example, a conciliation in the Fair Work Commission. A mediation is not about findings of fact. It's not about someone making a decision for the parties, telling them what to do, what the outcome should be. Mm-hmm. So in the sense that an investigation really is about working out what's happened, who's at fault, whether there's been any breaches of policies and procedures. That's not what we're talking about here. Okay. We're really talking about offering people the opportunity to have a discussion about what their concerns are, what the issues might be, and then whether or not there is any path forward for our agreed outcome, which is our second last point on that slide there. So you can see here there is a ADR continuum, as we've called it, which is the alternative dispute resolution continuum. So basically we're starting off over on the one hand with negotiation, so direct conversations between parties trying to resolve a problem. It can be a legal problem, it can be any type of problem.
Bargaining maybe, perhaps?
Bargaining in an employment context. We're really focusing over on that side of the screen with parties deciding on the outcome. So having some control over the process, how we get there, what the outcome looks like, how it's conceptualised, what the agreed outcomes and action items are. We then, if we aren't able to sort of do it in that informal way, potentially move into a mediation process, which is formal in the sense that we're talking about it here today, and formal in the sense that we might bring someone else in from outside to assist us with that.
So if I sat down two parties or two employees and I was just having a chat with them, that would perhaps be more in the negotiation or the mediation category?
It depends really, and it's sort of a bit of a, do we use the right word for the right thing in this sort of context? So a lot of people talk about mediation in the workplace in particular, and might be really talking, as you say, about a negotiation, a problem-solving discussion. It doesn't have the same kind of connotations or consequences as a legal mediation or a mediation conducted in accordance with the NMAS standards might have.
Which has a bit more structure around it, a bit more process-driven.
Absolutely, yeah. Okay. If we can't resolve it informally or through a mediated process, of course, we do end up having control given over to a court or tribunal or some other regulatory authority, and that's where we end up with no control over the outcome or the process, and basically, a drawn-out circumstance where, in all likelihood, no one's going to be especially happy with the outcome. So that's why, if we can, we try and stay over the other side of the ADR continuum.
NMAS practice standards. It's quite a mouthful, this NMAS acronym, but basically it's just the standards that have been set up by the body that accredits mediators, that sets out what mediators have to do in a process. And as it says, it has a formal definition of what mediation is. It's also got certain requirements for what an accredited mediator must do when they go through the process. And that's really about, firstly, identifying the issues in dispute, which sometimes you think you perhaps know what they are going in, and people bring up different things. It's about facilitating a discussion between the parties and then trying to get them to design and create outcomes that they're both happy with. It's not about giving legal advice. However, a lot of people who are accredited mediators, it's safe to say, do have a legal background, because obviously having an understanding of the legal underpinning of whatever dispute the parties have can often be quite helpful to helping navigate those issues and helping to explain the foundation that discussion is taking place on.
Yeah, and we will talk quite a lot in the course of the materials today about this idea of, trying to assist the parties in working out what the real problem is, because I'm sure everyone who's listening will have had this experience either in a professional or a personal capacity where someone seems very emotion driven about a particular issue, or there's a particularly heightened conflict that might seem to be about something, but when you really get down to it, it isn't actually about that at all.
Something was said 2 years ago that somebody didn't like.
That's right. Yeah, and that's the whole purpose of a mediated process. It's to make people feel safe enough to actually go back to the genesis of the conflict, the reasons why the emotions have become heightened, and in doing that, going through that exercise, working out what actually might facilitate a movement forward in a productive way.
So the different types of mediation, this is an interesting one because I'm sure most people watching probably have participated in some kind of conciliation at some point.
Yeah.
And often there's this idea, well, is the Fair Work Commission process, if you're involved in an unfair dismissal or GP, is that a mediation? In reality, it's not. Am I right in saying that, Kate?
No, it's not really, because if you've had that experience, you get on the call, you get on the Teams link, whatever it is, each party has that opportunity to say what they want to say about their case, and then most of the time you'll go into private conference. In that private conference, the conciliator will quite often be telling you what they think about the prospects of success of your case.
Add that pressure on top.
Yep, telling you all the issues that you've got with your case, and most of the time doing the same thing with the other party. And that's, I suppose, the key difference between conciliation and mediation. Conciliation is, more driven to find a resolution to prevent the matter from proceeding to a formal hearing, rather than the parties really being able to have that safe space to explore and reach a resolution and come up with solutions that they themselves have identified, rather than the conciliator.
And when you get to conciliation, you're basically already dealing with a legal matter.
Correct.
Whereas mediation can very much be commenced, and preferably is commenced, before you have any kind of legal matter that's taken hold. That said, though, we have put up that both the federal and Supreme Courts have ordered mediations. Most of them, if anyone's ever had a general protections matter that's headed off to the federal court or the federal circuit court, you might have been subject to an order to mediate. And that is really a recognition from the courts that if they can resolve things early, they want to try and do that. And that, again, is a slightly differently structured mediation, but it's the same idea in terms of getting people to explore the issues. Can we reach resolution and come to some solution? Although that probably is a little bit closer to the conciliation in the sense of what outcome could we agree to?
And having a realistic understanding at that point in time of your prospects of success, which does inform the discussions once you do have proceedings on foot. Some other examples there that you might be familiar with as well, family provisions, disputed wills, those sorts of matters, now quite often the subject of mediation, other forms of civil disputes, and then of course family law, a very common factor or feature of family law proceedings in the modern day and age. And again, really all of these things are trying to get parties to resolve things before they get to that outcome where a third party has to come in and decide for them.
Absolutely. Now, obviously, on this slide, we've put up a whole range of high-profile cases. Hopefully, some of them are in recent memory for a lot of people watching. But just wanted to give you a bit of a flavour of the fact that a lot of matters that get to mediation settle, particularly if they're coming from a court-ordered mediation, because at the end of the day, mediating an outcome where we'll cover a little bit later, it stays confidential, it is an attempt to give something that works for both parties, is often a far better outcome. But most of the time, frankly, most mediations and outcomes of mediations never hit the headlines because the very nature of mediation is that things stay confidential, they stay private, they stay between the parties that have been in that room and have come to that resolution.
Yeah, but of course one of the problems with that is we can't tell you how wildly successful these mediations are at resolving matters because we don't have that public outcome, which is part and parcel of the success. So we'll assume that mediation went especially well in the matters on the screen there.
There are a range of benefits of mediation, quite a lot of, I would say, benefits of mediation if it is the right type of matter.
Absolutely.
And we're going to touch on a little bit later what those are and where that kind of line is. But in terms of the overall general benefits, the first probably key one is that it can quickly resolve problems that can otherwise blow up and become bigger than Ben-Hur when they really didn't need to. We were on our way here having a discussion about sometimes when we deal with matters that get to, say, a bullying application stage, you often think, well, could this have not been resolved, 1 month, 2 months, 3 months back between these parties before it got to the stage of somebody putting in an application? Because it's really trying to nip things in the bud before they become something that feels charged or where someone might want to put in an application because they feel perhaps aggrieved by whatever has occurred.
Yeah. The other reality with time effectiveness and consideration for people to have regard to is if we do end up in the court or tribunal system, a resolution is many, many months, often years away. So if people want to, if they are, committed to continuing to work together, because that is the context we're talking about here today, then it's a far better outcome, far more efficient from a time perspective if we can get that mediation and that resolution happening before they have that third party come in and impose that decision on the parties.
And far cheaper, I would say.
Far cheaper for the same reasons, because you don't have to pay people like us to run those matters, barristers' fees, all those sorts of things. Also some, hidden costs potentially as well. I always say to people, if we can resolve something early and relatively acceptably to all the parties, it means that you don't have to spend the next 3 to 6 months talking to me every day on the phone about the evidence that we're preparing or the submissions that we're getting ready. So you can run the business, do your normal job and devote your time and attention to that and not to the thing that's otherwise going on in the background that is of course going to be very, very stressful. The other thing I think there that's really important is control and flexibility.
Absolutely.
So like we've said, once we get to the stage of a matter having to be arbitrated or determined by a court or tribunal.
Or even conciliated.
Correct, that's right.
It's out of your hands.
The parties basically lose that control over what the outcome's going to look like and what good looks like for them.
Yeah.
The other part of that is, people I think immediately assume mediation, conciliation, dispute resolution in the workplace context always has to be money related.
No.
People are chasing cash. And I think both of us would agree our experience, certainly in the mediation space, is that's not necessarily the case. Quite often people want to feel listened to, they want to feel heard, they might want an apology, they might want some things which ultimately, if you do go down that litigated path, are not really available to them as options to resolution. So having control, flexibility, that guidance from the parties about what it is that they see as being a good outcome or a good resolution to the conflict that they're facing is one of the major benefits of mediation.
Some of the other benefits I think are around probably the soft skill side of things, in terms of it is hopefully less stressful, hopefully particularly less stressful for any of your employees who might be involved. I often think by the time you're interviewing someone, for example, in an investigation, that cultural breakdown that's just occurred is going to take a long time to be resolved, even if you're just a witness in something that's occurred, because it's that, the fear, the anxiety. That doesn't occur with mediation. It's a lot calmer a process. It's a lot more safe and secure, I think, if you're looking at it from the perspective of your employees. So from that side of things, it's hopefully less stressful, but it's also from a psychological safety point of view can also be something that leads to a better outcome in that space as well.
Yeah. We've had a couple of questions about psychological safety. I think one of them was, and we might just touch on it now, about making sure that people are well enough to actually participate in a mediation process. There was a question about, should a doctor's clearance be something that we consider in circumstances where we're maybe putting two people together for the purpose of a mediation? What would you say about that? If
I had concerns about someone's mental health, then yes. If there's no indication that there's any type of concerns about someone's mental health, I don't think it's a prerequisite. I think it's all going to depend on case by case. But if you've had someone who's been off, perhaps they've said, I'm dealing with anxiety and stress, I'd want a clearance before I then said to them, yes, we're going to allow you to go and mediate this. I think that would just be sensible.
A sensible thing in the circumstances.
Absolutely. Confidentiality. Do you want to talk us through this one?
Yeah, so I think confidentiality is a really important consideration here. And again, had lots of questions about confidentiality and how information that comes up during the course of mediation can or might or would or be appropriate to be used in other contexts in the workplace. The bottom line, the fundamental principle is whatever's discussed in a mediation must remain confidential, except for a couple of notable exceptions. The first one being whatever agreed outcomes the parties determine that they're happy to move forward with. So it might be that they agree to particular commitments about communication or working environment changes or just certain things that are going to help the parties in resolving the issues in dispute between them. Naturally, it might be necessary and appropriate to tell other people about those things because it might need some operational support or some other support from resources within the business. The other, again, notable exception is where there's a concern about someone's safety.
Threats to other people or some criminal type matter that might come up.
Absolutely. But apart from those things, has to be confidential. That's one of the really key things about a mediation process is that we put those really strict boundaries around the process so that people do feel like they are able to freely speak, say what they need to say, get it all off their chest, have that really frank and honest discussion with the hope that in doing that, it's a therapeutic process and that can assist the parties in moving forward from whatever it is that the dispute has arisen out of or from.
That's actually probably a good reminder again about another question we got about whether or not you should record a mediation.
Yes, and I would say absolutely not. So one of the things that you learn and one of the things that's a key consideration for AMDRAS accredited mediators or people who have been through a formal course of study in relation to mediation is, what kind of records do we keep? How do we sort of keep track of what we discussed during the course of mediation and how is that used after the mediation? So certainly my preferred practice is to take my own notes during the mediation, but then to maybe keep them for a period of a couple of weeks after and then destroy the notes. Some people prefer to destroy them straight away. Some people don't take any notes at all. And so certainly coming back to the question that we had there, Tamsin, about recording, I certainly wouldn't be recording a mediation. I don't think that that's in keeping with the spirit of what we're trying to achieve.
Yeah. I think that's the real distinction again between, say, the investigation process where you might record because you want to make sure everyone's got the same factual basis. Because it's not a fact-finding investigation, it's about resolution. The whole idea about people being able to speak freely, really tell perhaps the truth about what's going on, that's the whole purpose behind this idea of not recording, keeping everything confidential, not discussing it once you leave the room, aside from whatever's been agreed.
Yeah. A couple of other things on the screen there. I think we've kind of touched on some of these briefly already, but sometimes coming out of mediation, neither party feels especially like they've had a win. And I think that's a really important expectation to set moving into the process is that you might come out of this going, well, at least I had the opportunity to have my say. I haven't had the person being forced to apologise to me because any outcome needs to be agreed between the parties. But is that going to be mutually disappointing for both parties? So they're going to have that opportunity, as we said, to talk about the issues. Neither party is going to feel like they have a win because that's not the role of the mediator. So are they going to then be able to sort of go, well, we've ventilated all of the issues, maybe now time to move on? And that will be one of those judgment calls for the person considering mediation as an option. So the manager or the HR business partner.
Yeah.
Are these the sorts of people who are going to be okay if there is no winner here, mutual gain or mutual disappointment?
Which is a nice lead into the other benefit about behavioural change. Often we see greater kind of take up or compliance with anything agreed in a mediation because there's that buy-in from the parties. Because at the end of the day, they're the ones putting forward the solutions. They're the ones having to agree to whatever's kind of being proposed in the room that they're willing to agree to. And often that will lead to a greater take up or compliance with, I suppose you could say, whatever has been agreed.
That's right. We do talk in a moment a bit more about this idea of future focus, restoration of relationships and those sorts of considerations. If you do have the reality of a situation which is that people do need to continue working together, there is no other option.
Yes.
Mediation can be a really effective way of actually trying to repair that relationship to the extent that that might be achievable. May not always be achievable, but certainly there'll be lots of circumstances where if you don't have some kind of circuit breaker process, such as mediation,
you might lose two good people, two great staff.
right.
And that's often what we hear from people. It's like, oh, they're both very good at their job, but they just can't get along.
they can't get along. And what do we do in that kind of circumstance?
So how does mediation actually work in the workplace setting?
Couple of things that we've already spoken about here. So often interpersonal conflict, like we just mentioned. So not a circumstance where there's a serious allegation of bullying or harassment or sexual harassment or you know, that type of behaviour which might be appropriate for us to investigate rather than mediate, but really people who are just not getting along.
That might mean, though, that people have thrown around the word bullying or harassment, but you might look at it and say, oh, hang on a second, we might just have some reasonable management style here that isn't kind of gelling with this person, or maybe the person's slapping a label on something because they're just having that communication difference and they're not getting along.
That's right.
So I wouldn't get put off by saying, oh, well, because it's a bullying matter or harassment matter or even sexual harassment at the very low level, that doesn't mean I can't mediate. It may, but it's all about can it work in the circumstances.
And so then the next point then becomes really relevant. It might be a circumstance where you have had a formal complaint made by one or either of the parties, and you have gone through an investigation process. So it might be that you initially determine that there is enough there for an investigation to occur. That investigation takes place, it's completed, the findings are whatever they are. Often they may be inconclusive. And then you might say, well, okay, there's not enough here to engage in disciplinary action against one or either of the parties. They need to keep working together. How are we going to move forward? And mediation might be appropriate in that kind of circumstance. The final one there that I just want to touch on is, and it's something we sometimes see in businesses where we've got lots of family or businesses in small communities where there might be relationships outside of work, whether there's been a disintegration of a marriage or other family breakdown, potentially even a personal sexual relationship that's occurred in the workplace that's then subsequently broken down as well. And again, the people need to continue working together, but the impact of those personal circumstances is influencing how they show up in that workplace environment. So giving them that safe space to talk about some of that stuff can be really helpful sometimes.
Some threshold issues to consider. These are really things you want to think about before you kind of pull the trigger and say, yes, let's mediate. And the first is obviously, do I have any policies or procedures that I have to follow? And you might find those in your written down policies, but you could also find it in any enterprise agreement that might require you to do certain things. You might also even frankly look to the Fair Work Act. Sometimes, for example, with the right to disconnect, one of the key things is you have to have tried to resolve the issue at the workplace level first. So you might, in some circumstances, consider that maybe that might be a management style thing that could be mediated if there's some disagreement about the contact outside of work hours. You then want to consider as well, is this an area where we should be looking into allegations of misconduct or contravention of a policy or procedure? Is this something where we think we might need to, for example, give a warning? If that's the case, mediation's probably not going to be the right fit because that can't be an outcome of a mediated process or wouldn't typically be an outcome.
That's right.
In that said, you might need to say, okay, let's do the investigation first, and depending on the outcome, we might then decide to mediate afterwards to try and get everyone back into the workplace together. You also want to think about the participants you've got. You probably know your employees very well. For some people, this would be a great kind of solution for them. For others, perhaps those who are a little bit more steadfast in their views, perhaps, or just simply people who wouldn't work well with expressing, feelings, emotions, things like that. Sometimes they wouldn't be the right fit for a mediated process. But it's really based on circumstance and what your understanding is about their personality.
I think a couple of other really important points to make there, and I really like this idea of, going down this path, Tamsin, of being really deliberate about the decision that you're making. Because I think one of the things that we often see, whether it's an investigation, whether it's a mediation or other ADR process, is people get a complaint in or they observe a conflict occurring in the workplace, and then because there's so many risks about which they need to be aware, they're trying to manage psychosocial hazard exposure, they're trying to...
Positive duty exposure,
workers' compensation, all of these things, they get very conscious of being seen to take action really promptly. And sometimes we can go down the wrong path if we...
Jump to an investigation straight away, for example.
That's right. Sometimes an investigation isn't going to be appropriate because what's the concern? What's the complaint? Is it actually something that I'm going to be able to investigate? Have I got enough information that I can particularise allegations and put them to this individual? Or is it just, I don't like the way he speaks to me? Those sorts of things. So those are the deliberateness and the decision making, I think, is a really important consideration at this very early stage. Another thing I think is really important is we don't want to be putting people in a situation where we're setting them up to fail. So suitability of the participants, as you said, personality is a really important consideration, but I would also say things like whether English is the person's first language.
It's a great point, actually.
Would be a really important consideration. So am I putting someone into a situation where I know that they're probably going to struggle because they're going to have some challenges in articulating some of the things that I'm going to be asking them to talk about. So those are all things, as Tamsin said, you as the practitioner are going to be the best placed person to work out who are the people, what do we think the prospects of success are likely to be. And then the final consideration on that side there, which is this something we want to keep in-house or is it something that may be more appropriate to ask for some external assistance with?
We'll come back to that in a little bit, I think.
Yeah, definitely. One of the really important things here, and I think this is a good juncture to make this point quite clearly, is that our employment relationship is founded on this master-servant principle. So I employ you, I tell you what to do.
Lawful and reasonable directions.
That's right. You pay. I pay you for doing the things that I tell you to do, and that's the basis of the relationship. That's not really a sound foundation for a mediation circumstance, though.
So I can't direct someone to a mediation?
I would be very, very hesitant about directing someone to participate in a mediation. You say this to people all the time, you can do what you like, but would
it be reasonable?
Would it be reasonable? Would it be lawful? These are the relevant considerations we need to have regard to. So if I'm directing you to participate, I think there's an immediate question there about, well, are you actually going to come to the process with the right frame of mind? Are you going to be open to being vulnerable and exploring the issues in a way that actually makes the process meaningful? And then are you going to be committed to working toward whatever agreed resolution the parties are able to achieve? So I think and I think that was one of the questions that came up quite a lot for us.
Yeah.
Should we direct and can we direct?
And that might be a bit more about educating people about what mediation is, because I think we do throw around these terms, conciliation, mediation, negotiation. People don't really understand. They're all just end in nation and people don't really get the difference. So it could be that gets people to understand and perhaps agree, but directing would definitely be something we wouldn't put on the table. Typically.
Yeah. And I think then you go, well, okay, if we're not going to direct and one person doesn't seem enthusiastic about the process, let's think about our other options. And we do still have other options. I think that's an important thing to remember.
So what does a mediator actually do? We touched upon this a little bit earlier when we were discussing the definition of mediation, but essentially they're there to guide and narrow the issues towards resolution. They're there to hear the emotion that somebody might put out, but then say, okay, what's actually the fundamental issue that person has that they're expressing usually in quite an emotional way. They're not there, as I touched upon earlier, to provide legal advice, but they are there to guide on issues that are typically in dispute. So having that kind of legal understanding and background, which is why HR practitioners and lawyers can be quite good as mediators with having that background and understanding. And then next is to act as a neutral referee. The goal is not to take sides, to say, yes, you're a winner, you're a loser, as you touched on earlier. It's to really be constructive and to force both of the two individuals to or however many others might be there to come to the resolution themselves. But to do that takes quite a lot of guidance, and sometimes it's pressure testing some of the things that people are putting forward and seeing whether that's actually a viable solution that they might have put out there.
Yeah. And I think as well, and I'm sure a lot of our viewers have had this experience, when people get into a conflict, they get quite stuck on things.
Yeah, they put the blinkers on.
That's right. And one of the benefits of having an external third-party mediator come into a workplace conflict, or any type of conflict really, is that they can try and guide that person past those issues that they've become stuck on.
Yeah.
Because I think you mentioned earlier that those issues might be from 2 years ago and they're manifesting in operational concerns or communication issues now. So what we really need to do is unpack those things, have that person feel heard about those issues, and then try and assist them in moving forward. And that third party can sort of have that helicopter view of those issues in a way that sometimes people who have been involved in the process to date will struggle to have.
So you set out here on this slide, Kate, an example of what a mediation might actually look like. Do you want to run us through kind of what the typical steps are if we are running a mediation?
So there'll be an introductory session with both parties separately, and this is a really important, I suppose, triage step. This is also one of the points at which us and we as the external third-party mediators will check again with participants that they actually do voluntarily want to participate.
And we wouldn't move forward, would we? If somebody
right.
wouldn't participate, we wouldn't.
Yeah. So you as the HR manager person, whoever it is, or your role within the business might have said, right, well, I've got these two people. They've both said to me that they want to mediate and they're happy to do that. You then engage us, we come in and we actually check, basically.
Yeah.
Check to see that that's actually the case, that they understand the process, what the process looks like. And after having that understanding, they're still okay to participate in the process. So that's a really important sort of first stage information gathering for the mediator. We then have a joint mediation session arranged, preferably in person. Very difficult, though not impossible. I can see the question down the bottom there about...
Can we do it online?
We can do it online. Certainly, my preference would always be to do it in person if we can possibly manage that. There'll be some circumstances, of course, that won't be appropriate or available. We might have people on different sides of the country and it's all a bit too hard to try and get them in the same room. There might be some safety considerations as well, but I think there'd be a real question in a workplace setting if there's safety considerations.
Should you be mediating?
Should we be mediating anyway? But in any event, certainly I think the best outcomes come out of an in-person session.
Agreed.
Do you want to talk about ground rules a little bit, what those might look like?
Yeah, we might. Should we jump ahead to the next slide? Yeah, let's jump to the next slide and then we'll come back.
Okay.
Where we've set out some of the critical ground rules.
Yeah, perfect.
The first one is that we need to have respectful relations and language. As you can imagine, if people start swearing or name calling or things, the whole process breaks down. So that's obviously a critical ground rule of any mediation that you might do or any third party might run for you. No interruptions. This is often a really tough one when you're having a mediation. We let people freely talk without being interrupted both by the mediator or by the other party. Confidentiality, we've touched on this a little bit, but it's really important that all the parties understand that they can't walk out and say, oh, they said this to me in the mediation. It is strictly confidential and nothing that's said in that room leaves that room besides whatever agreement is hopefully reached. Obviously, good faith participation we've discussed at quite a lot of length, but we want people to be there in good faith and to be happy to participate. It is very future focused. It's not so much about rehashing the facts and the dates and what was said. That might be required in order to get the parties kind of to the point of discussing a resolution, but it's not like we're going to say, oh yes, that definitely happened because you said and you've confirmed that and X, Y, Z. It's really focused on how can we move this relationship forward. Support person's an interesting one. What do you think, Kate? Do we let someone have a support person?
Generally, my preference is no, for a couple of reasons. One is I really want that person, the participant, to feel able and empowered to speak for themselves. The role of the mediator is to essentially support the person in feeling comfortable in doing that and feeling like they're not going to be interrupted, they're going to be respected, they're not going to be sworn at or yelled at. So hopefully the need for the support person is lessened. The second consideration I think that's really important is the idea of confidentiality. So the more people in the room,
harder it is.
the more likely it is that that information is going to somehow find its way outside of that room. The third thing is, again, we really want the parties to be the ones who agree on the outcome or the resolution. And as soon as you have someone coming in and being involved who's not directly one of those parties, you've got that added influence of perhaps well-intentioned, but certainly not necessarily focused on what that person's best interests actually are. So I think, unless there's some extraordinary reason why that person needs a support person.
Perhaps a translator, maybe? That would maybe be a rare example.
I think there's other things that we can do as well. So for example, if someone is saying, I'm really keen to participate in the process, but I do have some anxiety or some other psychological symptoms that I'm also managing at the moment, and that might be the reason why they've requested the support person, no problem. How about we talk about scheduling the mediation for a time when you can then have an appointment with your psychologist or your counsellor straight away after, so they can have that important debriefing, de-escalation point outside of that process. So lots of ways that we can kind of work through that, but as a general principle, avoid if possible.
Because it's not like we're concerned about procedural fairness. This is not a disciplinary process, it's not a performance management process. So all of those usual concerns around, unfair dismissal, have we allowed them to have their support person, just don't exist in this this orbit, because we're in the nice little kind of bubble of mediation that doesn't involve any of those things.
Yeah. And the final one on the screen, which I think is really important and goes back to good faith participation as well, is people should feel safe to say how they feel in a respectful way, of course, but to not feel like there's going to be repercussions or ramifications for that person down the track. So
and that's particularly important if you're the one running the mediation. People need to feel that they're not going to have, a warning notice given to them after they walk out of that meeting because they said they did something that might have been a breach of something.
Yeah, that's right. Yeah. Okay, so we've agreed on our ground rules. Each party has the chance to have their say. The mediator doesn't control what's discussed. That's, the mediator might guide the conversation. The mediator might try and get the parties to focus on, a handful of key issues, because these discussions do have the potential to sort of meander all over the place if they don't have some kind of structure around them. But it's really on the parties to be the ones to say, right, these are our opportunities for our things that we'd like to discuss, and these are the ways that we might be able to move those things forward. And that's that point number 5 there, options for resolution. The final thing, agreement reached on how to move forward. What's your preference about how to kind of get to that final stage? Do you like to record in writing?
I always think everything's always better in writing. I think it helps the parties be really clear about what's being agreed. Yeah. I think when you put it on paper or put it up on a screen through Teams, I think that just helps everyone understand. Now, that doesn't necessarily mean that that's going to be shared outside the room. I think it's often helpful to be able to at least share it with HR. But I think if you don't put it in writing, it just allows that scope for, that's not quite what they meant, or I misinterpreted, or I think it just provides clarity, though it's not required. Yeah. You can definitely, particularly if you say you're only agreeing on one thing and it was really clear to everyone, perhaps not necessary. But I think if you're dealing with a number of kind of things to resolve or move forward, particularly if you're checking in the future, putting it in writing is always really helpful.
Absolutely. Okay, so when is mediation effective? We've talked a little bit about some of these things, but I think there's a couple of things that would be valuable to touch on in a little bit more detail. My view is always mediation is most effective when we really don't have any other option but the parties continue working together.
Yes.
So I think you mentioned before the example of 2 really good performers, 2 people who are great at their jobs separately, no performance concerns, no real serious behavioural concerns or conduct matters that might be a breach of policy or procedure or otherwise worthy of investigation, but just things are not good and they're not getting along. And you as the HR practitioner can kind of look at this situation and go, this is not going to end well.
Yeah, someone's leaving or someone's making a claim or, you just get that vibe, that sense. It's going down a path you don't want it to go down.
So that's the kind of situation that we're really sort of thinking about, okay, is this an appropriate one for mediation? And as we've said already, I think earlier the better is better. You might think, well, I don't want to unnecessarily escalate by getting...
No one's made a complaint yet.
That's right. But if you've had enough sort of observations or conversations with people to say, well, you guys, things aren't great here, let's maybe nip it in the bud before it gets too entrenched. That's a really good opportunity to utilise mediation rather than some of the other more formal processes that we've alluded to already today. If there is a long history of conflict, do you think that means that mediation is not appropriate for us?
It all depends on the people and their willingness to kind of resolve those things.
Sure.
If you've had long entrenched issues, some circumstances may not be appropriate, but it actually could be quite helpful to get them to ventilate those and to say, yes, we're putting those in the past and this is the plan to move forward. Because if they have had, something that came up 2, 3, 5, 10 years ago and they're still holding on to it, it's not going to get better anyway. So mediation could be that solution that allows them to kind of say, okay, it's a fresh start. Here's the agreement of how we're going to, engage with each other moving forward. Do you have a view on it?
Oh, no, I think probably the same is that, often, best to avoid getting to a situation where we've got a long history of conflict before mediating, but certainly doesn't preclude us from going down that path.
Yeah.
And certainly I think there might be circumstances where mediation is a line in the sand. Or an opportunity for a new leaf, whatever metaphor you want to use. And it might be that point at which we say, right, well, here you go. This is your opportunity to get everything out, ventilate all of your concerns, agree on how you're going to work forward together in the same direction. And if that's not something which is able to be achieved, well, there might be a different path that we have to go down after that. And that's not to say that we're trying to coerce people into participating in mediation because, as we've said already, certainly we want willing participants, but it can be one of those circumstances where you might need to be realistic about consequences with people.
Now, I've touched on some of these other issues already here. Do we have high levels of emotion where it just might not be appropriate, particularly if you've got the more serious forms of, misconduct, or have we got people who just clearly can't communicate and maybe mediation isn't going to help them, it's just going to kind of make a more fractious relationship. It's all going to be based on your read of who they are, their background situation, what's occurred between the parties. Do you really think the parties are even going to abide by the agreement?
Yeah.
Hopefully, usually with buy-in, people will because they've been a part of the process. They're the ones that have suggested the solution and have agreed to it. But, not every personality type is going to abide by it because they still may see it's, directed by the company or the company is involved or their employer's involved. So just some things to think about before you kind of pull the trigger, I suppose.
I think the bottom line though sometimes, which is the bottom point on that slide, is sometimes it's worth a try.
Particularly if you see the path that you're going down, you're like, this is a bullying application, this is an unfair dismissal if this person leaves, this is a workers' compensation claim, and I can see it 6 months in the distance, and you think, what are my options? Do you think that's the...
Absolutely, yeah. So you might think, having regard to some of the other considerations we've listed there, I'm not convinced that this is going to be especially helpful, but if there's no real red flag saying definitely do not proceed down this path, I would still, in a lot of circumstances, suggest people consider it because, it might be the thing that stops you from ending up in one of those other outcomes. It might not be the thing that prevents someone from resigning, perhaps, but sometimes a resignation is better than some of the other outcomes that could potentially arise. So, sometimes it's maybe not perfect, but might be worthwhile nonetheless.
Which is a really nice lead into how successful are these? And it's hard to say because obviously it's notoriously difficult to find out how successful things are when by nature they are confidential. But as you can see on the slide, anecdotally, practitioners suggest it's between 60 and 85% success rate, which is pretty good. It drops a little bit when it gets into the courts, but we're still looking at a success rate of over 50%. Now, obviously, some of this data, as I think you can see from some of our footnotes, is a little bit old, but I would say that perhaps the more this is going on, the more frequently it's being used, probably the success rate is perhaps even higher than what's suggested on the slide.
Yeah, I'd agree with that. I think that those stats are a little bit out of date now, and I suspect the numbers are probably more positive. But as you say as well, we need to consider the fact that by the time people get into court-ordered mediation, we don't necessarily have the same level of buy-in that people do when they're voluntarily engaging in the process at a workplace level. So that would obviously have an impact on the numbers too.
So where is it suitable to actually do mediation? I suppose that's the big kind of $1 million question. Yep. When do I use it? When do I not? I think we've touched upon probably the first category here of personality conflict and interpersonal issues quite a lot, but I think that's really a really key area where you may have terminology being thrown around, as I mentioned, like bullying or even in some circumstances harassment, but you look behind the surface and you're like, hang on, it's not really meeting the definition, it's not really right. I've really just got a personality clash or two people who just don't like each other's style or method of work. it is, I think, smack bang in that category that you should be thinking about mediation.
Yeah, absolutely. And I think probably the first 4 or 5 dot points on that slide kind of fall into that category of people not getting along for whatever reason, whether that's communication, management style, not clearly delineated roles, responsibilities, those kinds of things. But there's a couple of more interesting ones on that slide that I think, maybe I'd encourage you to be a little bit more creative in where you're thinking mediation might be appropriate in your workplace. The first one, for example, is return to work after illness or injury.
Absolutely, particularly if you're getting a bit of pushback from somebody and you're in that situation where you're like, oh, do we, wait out the time? Do we wait till the statutory deadline hits us of 6 or 12 months, depending on what state you're in? Or do we really want to try and work with this person and bring them back? And I think it's always better to have someone back in the workplace than to have lost a good worker or to have to potentially deal with that whole rigmarole that is moving someone on after they've been on workers' comp. So it's a really great, I think, solution that a lot of people don't look to perhaps mediate kind of how that person comes back and what that might look like.
Yeah, for sure. The other one that I think would be worth a little bit of a plug is where you might be engaged in enterprise agreement bargaining or negotiation, and you've reached a bit of an impasse there. Now, we have Dr. Rod Harrison and our CEO, Nigel Ward, who are bargaining gurus who work with the firm as well. And whilst it might not be your traditional mediation in the sense that we're talking about it, having that third party come in and try and reach a bit of an impasse where the parties potentially have not been able to get past certain issues themselves can be helpful, again, before you get to that stage of the commission coming in and having that outcome imposed. That's right, and that's it's a reality given the legislative change of the past couple of years. So, like I said, be a bit sort of open-minded, I think, in terms of the circumstances in which mediation might be appropriate in the workplace, and just kind of keep it in the back of your mind.
Yeah. Particularly, I might just touch on 2 more if that's okay before we move on. But post grievance, I think you've touched on it, but I think it's a good reminder. If you've done an investigation, perhaps it's one where you haven't been able to substantiate something, but you're like, well, how do I bring these people back together? I've now done this whole thing. I've had all these witnesses involved. Maybe it was a bullying allegation and you're like, well, no, it's just been reasonable management action. How do you bring those people back together? Mediation is probably a good thing to consider. It may not be perfect in every situation, but I could consider a lot of investigations we've done where we haven't substantiated findings, where we think, well, okay, there's obviously going to be some cultural problems now. Mediation might be a part of that solution on repairing whatever's occurred as a result of that investigation. And last but not least, leadership disputes. I often find when you have that conflict between the CEO and the board, or very senior leaders in the board, and you're kind of thinking, well, how do we move forward, particularly when both people feel, like they perhaps are the more powerful of the two. Mediation can again be a great way of helping everyone move forward in a way that is in the best interests of the employer as a whole.
So when is mediation not suitable? Those red flag territory ones. I think, like we've said, any circumstance where potentially there has been a breach or a serious breach of a policy or procedure, so bullying, sexual harassment, those types of things, those are the circumstances in which you would, I think, immediately go, maybe not mediation in the first instance.
Only if it's very low level.
Yep, absolutely.
Very rare. If it's in the low level category, yes, but anything above that, absolutely not.
So certainly where we're talking about other types of behaviours, so criminality, power misuse, any of those types of things, not an appropriate circumstance in which mediation would be utilised. I think as well, you really have to turn your mind to what do you think the parties are looking to achieve? Because if you've got one party coming to you and saying, well, I'm happy to mediate, but only if the other party agrees to say sorry or to have a warning or to have some kind of punitive or punishment outcome, that's one of the ones where I'd say, oh, I'm not sure that this is really going to be
I want to have a discussion first about what the purpose of mediation is and how it works. And if that person really is still steadfast in their need for an apology, for example, I'd say, well, this is not the right fit.
And certainly that's not to say that might not be an outcome that comes out of a mediated process. But that can't be imposed on the parties, I think is the bottom line there. A couple of other circumstances just quickly. So performance concerns. Talk to us about that one.
If you're dealing with someone where they're just not working or performing or their capacity is not where you want it to be, mediation really isn't the solution. Because we're dealing with relationship interplay, that isn't something to be resolved performance issues at a mediation level, because it's not a relationship, it's simply capacity. So if what you're dealing with is purely a person who's failing to meet the standards you've set for them, and it's not an issue of management style, then usually mediation is not going to be appropriate in that circumstance.
Final one that I think is really important, where you know or suspect that the party might not be able to engage effectively. So I mentioned before, English language barriers, psychological health might also be one there as well. So just, where you know that person's probably not fairly placed to participate fully.
Yeah. So how do you kind of embed this in your systems thinking? Like, how do you move through and think, well, at what point would I consider mediation? We've put up some kind of options on the slide, but I think perhaps the one where we've discussed the referral form or the triage checklist, they're the kind of things you want to think. Is it safe for the parties to meet with each other? Are they willing to do this? Is it in one of those categories we spoke about earlier where it's an appropriate method potentially depending on the factual circumstance? Do I have a live investigation at play? These are all things you want to think through, and I would just step through logically and say, is this the right fit, by asking yourself some of those questions. But I would really be thinking about putting this in your arsenal as something to think about, because I know a lot of people in HR are really great at saying, okay, yep, we need to send this to an investigation, or we need to do, send it off to lawyers to look at, for example. But often I think mediation is one of those, nice to have to the side things, or maybe we just sit down and chat with people as opposed to thinking about an actual formal mediation to try and resolve whatever the issues are.
So I think we've mentioned that dot point too. So having some kind of reference in your grievance, bullying, scrim, work health safety policies, that's the kind of natural home.
Yeah, and that will again direct employees to think about it as being an option as well, like it is now with the right to disconnect, where people say, well, I've got to try and resolve this at the workplace level first. If you build that into your policies, then that's an expectation on the part of the employees as well, that this is something that they might need to consider going through before they make any more formal steps.
Sure. Okay. I think here's where we do the slight subtle plug for our own services, Tamsin. So I think the bottom line is, a lot of you are probably sitting there going, I'm an HR practitioner, I mediate all the time.
Yeah, and you probably do in a very informal way, and you probably do a very good job at it.
And you might even do it in a more formal way, and again, do a very good job.
Yes.
But I think there's a threshold question here where we need to ask ourselves, is this a matter where it would be more appropriate or more desirable for someone internal or external to mediate? So a couple of things to turn your mind to there. So have we already investigated? Did you do the investigation? If you did, probably not the best circumstance to then conduct the mediation as well, knowing all of the things that you know about the parties and what everyone has already said.
Yeah.
Perception of bias.
Particularly HR having that kind of label of being the employer, particularly if you're dealing with, I think, an employee-manager type dynamic. Sure. Maybe employee into employee, not so bad, but when you've got this power dynamic that might be off, having somebody who doesn't seem, absolutely impartial, I think can cause some issues.
And then finally as well, if you're going to be the person who's responsible for managing the situation moving forward, regardless of the success or failure of the mediation process, maybe better if you can remain removed from that. Again, given that you can't sort of unlearn or unhear the things that you might hear when you participate in the mediation process as the mediator. So if you know that we're going to give this a go, but maybe not convinced that it's going to go especially well, or there might be a range of other complex contextual factors at play, you might say, well, better if I can maintain a degree of separateness, in the same way that it is appropriate often to outsource an investigation. Yeah.
So what are the benefits of having a neutral third party? Well, I think we've touched on some of them, but one of the big ones is that they don't know the history and the personalities involved. Often if you are HR, you've been involved quite along the way. It could be a number of years you've been involved in a dispute between individuals. So not having that, not bringing that baggage, I think can be a real benefit. Also, you're not invested in the outcome in terms of having an outside impartial third party come in. Doesn't really matter to them whether the resolution whether the matter is resolved. Whereas if you are inside the company, I think there's a little bit more of a impetus on, this needs to be successful, otherwise I haven't been successful.
I think the other really important benefit with having someone external come in is it is more likely, though not always guaranteed, that people will feel okay about being vulnerable.
Yes.
And vulnerability and being open is one of the key components to the success of a mediation or failure of a mediation, quite frankly. So the more we can encourage people to be vulnerable, to be open, to be able to communicate in a safe space, the more likely we are to be successful. And if they know you and if they're worried about showing emotion in front of you, whether that's anger, sadness, distress, upset, whatever it may be, the less likely they are to be open to feeling those things, open to engaging on that level with the other party. So I think there is that significant benefit of having that third party come in. But the same token, that person, again, like you said, doesn't know all the parties involved. So it does have that capacity to take that helicopter view, look at things a little bit more objectively than you do sometimes when you're in the business, managing the people, having to deal with something on a daily basis.
Yeah, it is important to know if you do go and use a third party. I know we've said this, but I think it's just important just to clarify it again. You will likely only find out what is agreed between the parties because of the confidential nature of that, because no one's keeping any records aside from maybe some loose notes. It's not like you're going to get a report back from the mediator about what was discussed, etc. You're just going to find out that this has been hopefully resolved and this is the agreement that they've come to. That may mean you need to have a pre-discussion about what's kind of within the capacity of the business to allow happen, but you won't actually know the machinations of what came out in that discussion.
And that's, I think, a really important expectation setting issue for all of the parties to understand, is that, you know, this is really about making sure the parties can come to an agreement and that they're happy with the outcome rather than all of that being reported back out to some third party.
Yeah. We're back to this horrible acronym, AMDRAS. We just thought we'd just flag this, particularly for anyone who might be interested in what's the difference between me mediating and somebody who's an accredited mediator. Well, if you're an accredited mediator, you've gone through the process of becoming accredited, which means you've met these standards, and the way that the mediation is conducted will be in accordance with these standards. And there are very set kind of procedures that have to be followed in order to be meeting the AMDRAS standards for holding a mediation. If you ever have heard of MDRAS, sorry to mention more horrible acronyms, but that has now changed. They've kind of been updating it, and I think as of the 1st of July, we've now moved from NMAS to AMDRAS. But just if you see any of these similar acronyms, they're just all talking about standards that an accredited mediator has to meet in terms of the procedure that they follow when they run the actual mediation. If you are looking to find someone who is an accredited mediator, you can go on to the AMDRAS board, I think, website, and they've got a list of accredited mediators there that you can go through, and that will also mention someone's speciality. So if you're looking for a particular type of mediator for a particular type of problem, obviously workplace being one type of speciality, but there may be need for, you know, slight nuances to that.
Yeah.
It's a very helpful resource for finding someone who might be the right fit, particularly as that person will also have professional indemnity insurance, which was raised with us again.
Question, yes.
About, well, how am I protected in this process? If someone is accredited, they do have professional indemnity insurance to be running that mediation, which I think is a nice additional layer of protection, particularly if you've got concerns about people maybe making applications down the line.
That's right. Okay, so just before we finish up, a couple of common questions. Can mediation occur after investigation or disciplinary decision?
I think we've touched on this very lightly, but it absolutely can. It's not going to suit the end of every investigation or disciplinary process, but if you've got a situation, particularly I think where, you know, you've had an outcome, but all of the parties are remaining in the workplace and you're needing to move forward, I think it can really be actually a very helpful tool in that situation.
We've done records, so should we keep records of the mediation? Generally, no.
No.
What if one person refuses to participate?
As we've said, if you had an accredited mediator, they'd be unlikely to move forward, and we would not suggest, frankly, that you give that direction to somebody to participate. Ultimately, maybe you could lawfully, but we really, really strongly would not recommend it.
This idea of legal professional privilege comes up, whether we're talking about investigations or mediations.
Is it legally privileged?
No, it's a process that's been conducted for a particular purpose. And so it needs to be done in that way, in that spirit.
It is confidential though, of course. So it kind of has that added benefit. And having a lawyer does mean that they still have to meet the ethical standards when running the mediation. It's not like that just disappears.
That's right.
But it doesn't have a legal privilege overlay on it.
And probably that leads us nicely into question 5. Can the information be used later against you?
Absolutely not. It's a closed book. Nothing can come out later in terms of investigations or proceedings, which is the reason why really we don't keep any records, because we don't want to have to be in a
held to
in a witness box telling everyone what happened in the mediation. What happens if someone doesn't keep the commitments they agree to in a mediation case?
Yeah, really good question, and often, unfortunately, does arise. We go through a process, things end really well, everyone walks away quite happy, and then time goes by, people are not committing or not keeping to the commitments that they've given. It's a performance concern. It's a disciplinary issue, depending on the nature of the behaviour, of course. So we use those other tools in our toolbox to manage those types of situations.
Now, this has come up as a question that we've had sent in as well, but does mediation satisfy my work health and safety duties? Does it satisfy my psychosocial risk kind of matrix?
Again, I'm going to use the toolbox analogy. It can be one of the things in your toolbox that you might use.
Yeah, absolutely.
So definitely can be a strategy. It might be something that you try and implement where you've already identified a hazard.
Control measure in effect.
Absolutely.
But it's not the only control measure.
That's right. And also it needs to be considered of its own accord.
Yes.
As potentially giving rise to some risk or some additional risk as well. So yes, can be helpful. Certainly not a cure-all.
Last but not least, will mediation stop someone from making a workers' comp claim or a legal claim against me?
Hopefully.
That is the goal, I suppose.
That is the goal.
The whole reason you do this early is so that you don't end up with a bullying application, or you don't end up with somebody leaving and then making it unfair or making a workers' comp claim. But it's not a panacea.
No, it doesn't prevent someone from doing either or any of those things is the bottom line. But like you say, what we're working toward is trying to avoid those things happening by diverting people down a different pathway.
Yeah. Now, we have had a few other questions sent in, so while I pull some of those up, I might just read one of the few that have come in already. What about being personally sued if you run a mediation session? Is that possible? If I'm HR and I go and run a mediation, could I be personally sued for what's occurred?
As we were saying before, one of the benefits of having an AMDRAS certified person coming in and doing your mediation for you is that they have professional indemnity insurance. The risk that arises if you're conducting mediations internally as part of your normal work is that, unfortunately, if things do go badly, there can be potential consequences. And yes, you might try and set up confidentiality, and you might try and set up the expectation that nothing said in the context of that mediation can be used against either party thereafter. But if things go really badly, there's no guarantee that any of those things won't happen. So that would be my cautionary message for conducting mediations in-house.
I've had a question in, there's quite a lot of questions actually about what do you do when somebody doesn't want to participate? When you've had a breakdown, you've got no other option, you've got a reluctant participant. What do you do in those circumstances, do you think?
I think the first thing, if I really thought it was important and I thought that mediation could actually resolve the dispute or resolve the conflict between people, I would maybe even consider engaging a third-party mediator, firstly as a gesture of good faith to the participants, to say, hey, we're actually willing to spend some time and money on this, so that they have a level of assurance of independence that perhaps they don't have if the mediation is going to be conducted internally. The second thing I would do is I would brief the mediator about one of the parties not being convinced that this is an especially good idea, and see whether or not in that intake session that mediator can talk to that person about their process and then hopefully get them to a point where they feel comfortable to participate.
Because it may just be a lack of understanding.
Absolutely.
As I said, there's a lot of Asian words that get thrown around, negotiation, mediation. It might just be someone not understanding really how much they will own the process.
That's right. And the safeguards that will be there to make sure that they are able to participate. But if someone still gets to the end of that process and says no, what do you think our options are?
It's a great question. I think if somebody doesn't want to participate in the mediation process and you have gotten a mediator and they said no, they still don't want to go, they understand the process, I really wouldn't be pushing forward. I'd be looking to the rest of the arsenal you've got. Is it a situation where you're going to need to engage in some more coaching or performance management or investigate whatever's been going on? You're going to need to go down another path, I think.
Yeah, and that's basically, there's two pathways here, isn't there?
The formal one or use what would, I suppose, is slightly less formal in the mediation world. Yeah.
Unfortunately, I think we're out of time, but we do need to would like to, don't need to, flag some additional services that ABLA can provide to you if you are interested, or if some of the things we've talked about today have maybe given you some pause for thought. So we do have a new section on our website about workplace mediations. There is the capacity for you to click on that, I think, in the course of the slides already. There's some very high-tech technology going on in the background there, but in any event, we do have a special landing page on our website if you are interested in hearing more. You can join Tamsin for positive duty training on the 24th and 25th of September. We're then also running performance management and workplace investigations later on in November. We have our toolkits.
Yes. Absolutely. And as always, if you ever need any assistance or perhaps you've got an issue and you're just wanting that second opinion on is mediation the right fit, just pick up the phone. Our email address is there as well as our phone number. But otherwise, contact us directly. As mentioned, we are accredited mediators. We do have a good sense, I think, now of when it's appropriate and when it's not. So if you do just need that second opinion, don't hesitate to get in contact.
Thanks for joining us.
Thank you.